Hi. You'll notice by my somewhat unbranded slides that I'm not actually currently with a law firm. I resigned from my current job at the end of April. And as you can see, I'm taking May off, so I came here for fun. And it is fun. So I'm going to talk primarily about the Renters' Rights Bill. It's quite a complex bill. It's one of the biggest changes in the rental sector really since the Housing Act 1988, so it's a big thing. I'm obviously not going to go into a lot of detail because I'd like you to stay awake as not to say anything else. But I'm sure you can ask me detailed questions if you want to. Or, even better, you could ring Baker and Chase tomorrow and ask them all the detailed questions so that they have to answer them. Right, so obviously the Renters' Rights Bill feels like something new from the Labour Party, but it's not really. This has been around since 2019 as a concept. The previous government introduced it as the Renters' Reform Bill. They are conceptually exactly the same bill, and despite the Conservative Party now saying it was nothing to do with them, it kind of actually was. And all the people who are now voting against it were previously voting for it, although apparently they didn't agree when they were voting, is what they're now saying. But that's a bit of a thin line to run, I think. But conceptually, it's very similar, and in fact, much of the text is the same, because unsurprisingly, if you ask someone who writes legislation to do the same thing twice, they'll probably do it in exactly the same way. And also, of course, the government needed to do this quickly, so it was much easier to simply adopt something that already existed and roll it out. But there are some key changes, there are some important changes in the text which matter in terms of how it operates on the ground. So the most obvious thing I'm sure you've heard about, though to my mind actually not the most important part of the bill in the end, but certainly the flag issue that most people get excited about, is that there is no such thing as a Section 21 notice going forward. You will have to give a reason to ask a tenant to leave. And there are no fixed term tenancies, so in principle tenants can leave whenever they want to, but equally they can stay as long as they want to, and in principle at least forever, subject to particular grounds of possession and you having a reason to possess the property. Now, what the government intends and what most people expect is this will actually be a positive thing in a sense, because it will mean that most tenants will tend to stay longer. And the reality is, for most landlords, it's not a problem, because most tenants are actually decent tenants. It only becomes a problem if you have a small minority, really, of problematic tenants, and then it becomes a lot more complicated. If you try to get around this, and one of the things that certainly concerns me about this is not you guys, it's all the people who don't know this is happening. We'll never know it's happening until it happens. I still get people who phone me now asking about tenancy deposit protection, which has existed since 2007, so they're a little bit out of date. But one of the big problems with all of this is if you try to grant a fixed term tenancy, or you purport to send someone a notice to quit or a Section 21, you will be committing an offence. The local authority, and the current local authority here is quite keen on this sort of stuff, is entitled to penalise you and serve you with a civil penalty, and there are other associated penalties as well. The other problem with all of this, and I'll talk about this again later, is it's very much a D-Day thing. Seems strangely opposite currently, given I've been hearing about D-Day constantly on the news. That all of this happens immediately, so all existing tenancies convert on D-Day from assured short-hold tenancies to the new structure instantaneously. So while it's not retrospective, it kind of is, in that it will affect arrangements you already have in place. Rents are actually where I think things are much more complicated. So at the moment, of course, you're pretty free to set whatever rent structure you want in place. If you have a tenant who hasn't got very good credit history, for example, you might ask them to pay some of their rent in advance, particularly if they're self-employed or coming from abroad or something like that. All of those options go away. The only acceptable mechanism is monthly rent or less. Obviously, I'm sure most of you aren't going to go less, but people sometimes use 28 days because it aligns with housing benefit payment. But that's the only one you can have. So any form of rental advance is simply not possible. Also, at the moment, it's pretty common to take the rent before the agreement is signed for the first month. So what you do is you ask the tenant to pay the first month's rent, assuming the money turns up, you then sign the tenancy agreement and they move in and all is well. That's not an option. You can only take the rent once they sign the tenancy agreement, which creates a risk, of course, that some tenants will purport to say, we're going to pay you, they'll sign the tenancy agreement, the rent won't in fact turn up, and then they'll expect to move into the property anyway, which they are legally allowed to do because you've contracted to let them move in. So there's a bit of a concern about that, though there are a couple of possible ways around that people are working on. But that's a considerable risk increase in the early stages of tenancies with tenants you don't know. And of course, one of the things therefore people are getting particularly interested in is how can we improve rental referencing and how can we increase certainty around that. I'm sure we'll talk about that later on. There's also problems with, for example, tenants who want to shift rent payment days, because the normal way you would shift a rent payment day is ask them to overpay 1 month to cover the gap. You can't do that because you can't take more than a month's rent. So you'll have to let them underpay and then hope they pay the month in a bit. Or alternatively, you'll just say, no, I'm not prepared to shift the rent payment day. It's your problem. You sort out getting the rent into my account on whatever day I see fit. And that's probably where most people, I suspect, will end up in practice. Tenants. Obviously, tenants can, as I've already said, leave at any time. There is no fixed term. So in principle, a tenant could move in and ask to move straight back out. The government has combated this by saying that tenants have to give at least 2 months' notice. So in principle, a tenant could move in, give 2 months' notice and move back out again 2 months later, though I think that's probably quite unlikely. But part of the associated problem is also can't specify the means of notice as long as it's given in writing. So it's possible that tenants can give notice by text message or WhatsApp, or I don't know what your preferred social media mechanism is personally. I mean, I'm quite good on LinkedIn, but any kind of direct messaging structure that allows people to give you notice, in theory, is a possible one. And that's a bit of a challenge for, especially for agency businesses, in order to make sure that they're capturing those notices. What is quite interesting about this, though, is at the moment, if you have a group of joint tenants, if one of them gives notice, then that doesn't affect inside a fixed term. But as soon as it's periodic, if one of them gives notice, it affects all of them. And therefore, one of the things that's going to happen here is if you have a group of tenants, if one of them gives notice, then that is a notice binding on all of them. And it therefore is a backdoor route to getting tenants to leave. If you can persuade one of them who wants to leave to give notice, you could use it on all of them. This is actually commonly done. Social landlords do this all the time. But it is a considerable problem in the student sector, because obviously if students groups fall out or one of them drops out of university, at the moment landlords tend to say, well, this is just not my problem. You've contracted for a year. But of course, one of the problems in the student sector is that student tenants will be able to just say, well, I'm leaving, and the whole thing will fall apart, and a landlord is left with a vacant property potentially halfway through a student year and having to find some alternative group of people to fill it up. Possession. So Section 21 goes away, so you always have to have a reason. So the existing Section 8 notice that we might have heard of, for example, for rent arrears and things like that, will become the only mechanism to obtain possession, and you will then have to have a reason or a ground for possession. But just to make things all more complicated, of course, that means that a lot of the flexibility of Section 21 goes away. Section 21 was used for a really wide range of issues, from antisocial behaviour to wanting to sell to low-level rent arrears, or just because I just don't really like this person that much. Most of those options aren't not liking somebody is not a ground for possession under Section 8, just so we're clear. I assume you probably knew that. But you need to have a reason every time, and therefore it becomes more complicated. Some of those grounds aren't mandatory, they're discretionary, so it's up to the judge whether it's appropriate in each case to give you possession, which makes it more complicated as well. And in almost all of the cases, notice periods are longer. Just to add to that as well, is if you give notice and use a ground for possession without a reasonable belief that it's true, that is also an offence, and it's liable for a civil penalty. So one of the big concerns about this is landlords might try and put a ground on there that they don't believe to be true, and think that that'll be all right, but actually it's not, and it's quite a serious matter. So I'll talk about some of the more common areas, so I'm not going to talk about all of the new possession grounds, because we would in fact be here all night, because there are now like 35 of them, as opposed to the 20 odd we currently deal with. But I'm going to talk about some of the key ones. So rent arrears possession is in some sense the same. So there are 3 grounds of possession under for rent arrears at the moment. Ground 8 is a mandatory ground of possession if there are 2 months arrears. Ground 10 is if there's some rent arrears, and ground 11 is if there's persistent lateness in payment, and they're both discretionary. It's up to the judge whether you get possession or not. Grounds 10 and 11 haven't changed. Ground 8, though, has been altered. There has to be 3 months rent arrears, not 2. and the notice period is doubled from 2 weeks to 4 weeks. So in practice, that means if there are rent arrears, there needs to be 4 months of arrears, pretty much, before you're realistically able to start court proceedings for possession. And obviously, if you bear in mind that depending on where you are, the court average at the moment is 7 months from the start of proceedings to getting possession, and accelerated possession proceedings under Section 21 will no longer exist, so the quick, easy route goes away. You can see that you're looking at potentially up to a year of arrears before we were able to get a property back. So one of the things that's going to become very important is early capture and early management of these problems and more effective handling of dispute resolution to try and avoid these situations arising. Because often tenants have a reason why they're not paying the rent, maybe not a very good reason from your perspective, but a reason of sorts, and trying to capture those reasons and address them early is going to be one of the most important issues around it. In fact, one of the main things that agents are going to find themselves doing is trying to capture issues much earlier in the process and deal with them before they become serious problems. If you want to reoccupy the property yourself, that's one of the new updated grounds. It's been around for a long time, but at the moment you can only use it if you want to occupy it yourself or your spouse wants to occupy it. It's been expanded to include children, so one of the ways to reoccupy the property is to let the kids occupy it. And I suspect quite a lot of people will actually use that, because of course many landlords do hold property with the intention at some future date of their children acquiring it, either for temporary purposes while they go to university or longer term. So this will be a ground possession. Unlike the current setup structure, you have to tell tenants before the tenancy begins that you might use it. That goes away, so a lot of the annoying sort of technicalities around it go away. But, and this is a big but, the government isn't stupid. So when this was proposed under the previous structure, lots of landlords went on social media and said, oh, well, I'll just tell my tenant I'm intending to reoccupy the property, but I won't really, as a means of getting rid of them. So unsurprisingly, government actually reads social media too. It's shocking that, isn't it? So they created a way of avoiding this. And the problem with this is once you give notice, it's a 4-month notice, and then it's a further 12 months once the notice expires, during which it is unlawful for you to relet the property at all. So you can give notice, and you can give 4 months notice intending to reoccupy the property yourself, but if you were making it up or you change your mind, your property is going to sit vacant for a further 12 months. And if you choose to relet it, it's illegal to market it, it's illegal to let anyone occupy it under any basis at all, and also the previous tenant and the current tenant can come after you for their rent back, up to 24 months rent back. So it's not a good idea to lie. Obviously lying is a bad thing anyway, but I'm a lawyer, we're used to people telling lies. It's quite a lot, but you shouldn't, okay? As I try and tell my 6-year-old daughter all the time, it doesn't work. So it's quite a huge block, and so you need to be very serious about it. Linked to this is possession to sell. There is a new ground for possession, unsurprisingly, if you want to sell your property. It was one of the most common uses of Section 21, but it has the same restrictions. If you want to sell, it's a 4-month notice period, and then a further 12 months from the date of expiry of the notice, so 16 months in total, during which it would be an offence for you to attempt to market or relet the property at all. So again, if you want to sell, which is fine, you need to be very, very clear that you've got the price right and that you're serious about selling, because as soon as you serve the notice, you're either leaving the property empty or you're selling it. Those are the two options you'll have available. No other possibility will arise. So you can't change your mind and relet it. Now in practice, I think in both of these cases, what will actually happen a lot is there'll be a cash for keys type deal. And what landlords will say is, I want to get possession of the property. Tell you what, it's an annoyance for you. I'll give you some money. I want to sell it, but I don't want to serve you the formal notice. And provided you never serve the formal notice, the 16-month restriction doesn't apply. So there's a way around it. But obviously it does involve you paying money. But in reality, of course, I think tenants will also be wise to this. If you serve a tenant with a 4-month notice intending to sell, if I was a tenant, what I might do is I'd wait till the 4 months was expiring. I might have noticed that the same person had come and seen the property 3 or 4 times, so they were quite keen to buy. And then what I'd say is, well, I'm really trying to move out, but I'm really finding it hard to find somewhere. What would really help me find somewhere is about £4,000. And if I didn't have that £4,000, I'd have to wait and make you take me to court for the next 7 months, watching all your sales disappear. So how about we come to an arrangement? So in practice, I suspect coming to an arrangement before serving the notice is going to be a better way forward. There's going to be a lot more of these kind of negotiated arrangements, I think, under the new system. Rental bidding. Another thing that you're going to have to take into account is the way that the properties are marketed. At the moment, it's quite common to market a property, particularly in London, and you accept whatever offer comes in. And often those offers are above the price that you marketed at, particularly as you head into central London. That is not an option going forwards. The price is the price, and you can accept bids up to that price, but you can never go over the price. So it's particularly important from that perspective to use a good agent, obviously, who has a good idea of what the actual price is on the market, because if they price it too low, you're losing money, guaranteedly, because you'll have to reject offers above the price. Now, of course, the flip side of that is you might decide to give it like a massively high price, and you say, well, my property's like £1 million a month, and I'll just take any number up to that £1 million. But of course, that has two downsides. One, if I put it on £1 million a month, no one's going to find it on Rightmove because it bans things that way. And two, tenants are entitled in the first 6 months of the tenancy to go to the tribunal and have the rent reduced and backdated down to a market level. So you might think you're being massively clever by putting on a high price and taking the highest offer that comes in, but the reality is that tenant might be lying to you and has no intention of paying that price. They've given you a high offer to get the property, but then go charging straight off to tribunal and say, well, this is massively over the price. So it's quite important to really understand the local market and price it keenly, but not so massively keenly that you end up in a situation where no one looks at it or the rent is just reduced later. New discrimination rules. So I'm sure most of you thought about pets. Those are not terribly important in my opinion, but it'd be unlawful to discriminate against tenants on the basis they have children or that they're on benefits. So those kind of adverts will no longer be permissible. Obviously there are limits to this. If someone has children, it would overcrowd your property. You're not required to put like 20 people into your two-bed property, because that would be a statutory overcrowding, and you can say no despite the fact that many of those people are children. And equally, just because someone's on benefits, if they can't afford the property, they can't afford the property. Being on benefits doesn't change that structure. But you're not allowed to refuse people who are on benefits just because they are. That said, obviously, if you've got 7 people applying for your property and they're all about the same and 2 of them are on benefits, who am I to tell you how you made your decision? Just don't tell me how you made the decision. Written terms, I assume this is fairly obvious, but all tenants must have a written set terms to their tenancy. Currently, you're not required to have those things, but that will be a statutory requirement. But what's complicated about this is the government will be allowed to dictate those terms, and also more specifically on D-Day, when all of this happens, you'll have a month to sort out an updated tenancy agreement for your existing tenants. There's quite a lot of admin work to do that. The government's also intending to introduce the Decent Home Standard, which exists in social housing, and that will be structured into something called the Housing Health and Safety Rating System, which already exists. But what's important about this is currently the HHSRS only applies when the local authorities inspected your property and told you to improve it. Decent Home Standard applies all the time, and if they inspect your property and it's substandard, you can be fined, and then they will also tell you to improve it. So there's an added pressure. I'm hoping that from almost everyone in this room, this is a neither here nor there issue, because undoubtedly your properties are pretty damn good. Otherwise, frankly, you probably wouldn't care anyway about legislation. I tend to find people who actually turn up to these things run pretty decent ships. So in a sense, I think this is a good thing, because what we're actually attacking here is all the people who are undercutting you in the market by offering horrible properties at overprices and just simply not complying with the law at all. Awaab's law, you've probably heard about in the news, so to deal with damp and mold growth, also being expanded from the social sector into the private sector. Not clear what it will look like, but what it will do is basically impose tight time limits for you to address complaints of damp and mold growth and other hazards. But we'll have to wait and see what the details look like. Again, I'm hoping for most of you this is not really a major issue. Pets, as I've already said, there's a lot of noise about this. You can still advertise properties as no pets, you can still refuse tenants on the basis that they have pets, but once a tenant is in place, they can ask you for a pet, and you cannot unreasonably refuse it. You can refuse automatically if it's a flat and there's a superior lease that says no pets and you can't get permission, there's a way around this, because you could let the property to a company controlled by you with a no pets clause in it, and then there would be a superior lease, but that's just another small possible way around the legislation. So otherwise you'll need an incredibly good reason, and I don't want pets in my property does not class as an incredibly good reason. I mean, when I say that, what I mean is it would have to be unsuitable, or their idea of a pet is like a small pet cow or something like that, which is probably not appropriate. I am very tempted to rent a property and get a llama though at this point. Rent repayment orders, I'm sure most of you've heard of these. I hope you don't have to deal with them, but they're being extended across a much wider range of issues and doubled from 12 months rent to 24 months rent. And instead of 12 months to come after you, you've got 24 months. So there's massively increased pressure on getting administration and getting this stuff right. And that will, again, I hope, to some extent, rub out bad landlords, but obviously you need to make sure you're not caught up in it by mistake. Commencement, it's a bit hard to say, but as I've already said, all of this is going to happen on a D-Day. The reality is the government is going to have to get rid of Section 21, ASTs, fixed terms, and put in the new Section 8 stuff all in one hit to make it work. I think they'll probably also do some of the changes to rent, and then some of the other stuff like there's a landlord database and redress schemes and things like that, which I just haven't time to talk about tonight, but they will probably happen a bit later on. The government was originally talking about September, this summer or October. I don't think they can do that now. I think in reality, early next year is far more likely. Thank you very much.